All right, I apologize. Uh, I accidentally hit the stop button on my recording device. Okay, but I believe I left off with the Fourth Amendment. And continuing to read on through the Department of Justice statement, it says the Fourth Amendment guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fourth Amendment traditionally has been deemed to protect private citizens' personal effects. The Supreme Court has treated the term effects as being synonymous with personal property. The interests animating the Fourth Amendment's prohibition against unreasonable searches and seizures are heightened when the property at issue is also protected by the First Amendment. The Supreme Court has held that Fourth Amendment limitations on law enforcement officers' authority to seize individuals' property must be scrupulously observed when the item seized contains information protected by the First Amendment, and the basis for the seizure is disapproval of the message contained therein. And it goes on to say Walter v. United States. This requirement that government officials closely adhere to the strictures of the warrant requirement when the item to be seized is protected by the First Amendment recognizes that the Bill of Rights was fashioned against the background of knowledge that unrestricted power of search and seizure could also be an instrument for stifling liberty of expression. We have long recognized that the seizure of films or books on the basis of their content implicates First Amendment concerns not raised by other kinds of seizures. Indeed, the seizure of material protected by the First Amendment is a form of prior restraint, a long disfavored practice only permitted in limited circumstances not present here. The Supreme Court has recognized that seizing films to destroy them or to block their distribution or exhibition is a very different matter from seizing a single copy of a film for a bona fide purpose of preserving it as evidence in a criminal proceeding. When material falls arguably within First Amendment protection, an officer's warrantless seizure of that material brings to an abrupt halt an orderly and presumptively legitimate distribution or exhibition of that material. The Fourth Amendment is violated. And it goes on to say Roden v. Kentucky. Such excuse me. And the document goes on to say police officers are barred from exercising prior restraint. Such seizures prohibit the dissemination of material protected by the Constitution, and so forth. So, the Fourth Amendment protects the citizen's right not to have their belongings taken away. Okay, we'll get to the 14th Amendment. This is page 15 of the Department of Justice Statement of Interest. The 14th Amendment protects, I'm going to read verbatim from the page 15. The 14th Amendment prohibits the seizure and destruction of property without due process. The 14th Amendment prohibits state and local officials from depriving any person of life, liberty, or property without due process of law. And that's, and basically Mr. Sharp had alleged that they destroyed his cell phone content and he didn't have a chance to contest it. Now, I'm going to read page 16, paragraph 1. A private citizen's constitutional right to be heard is a basic aspect of the duty of government to follow a fair process of decision-making when it acts to deprive a person of his possessions. And that is Fuentes v. Shevin. By mandating that individuals be afforded an opportunity to be heard, the Due Process Clause operates to protect the use and possession of property from arbitrary encroachment, to minimize substantively unfair or mistaken deprivations of property. I'm sorry, my throat is drying up on me. But I just have a little bit more to do, and I'll be finished. But I'm really doing this so what happened to me hopefully won't happen to any other citizens in Maryland and, you know, Prince George's County residents. So that's why I'm just reading this over for my fellow citizens. I'm no lawyer or nothing like that. I'm just an average citizen that's been reading and studying this because I was just outraged at what the police did to me. Okay. 14th Amendment's been covered. Now, this here is the United States Court of Appeals for the First Circuit. Simon Glick v. Plaintiff, Boston Police, John Conniff. I believe this is part, 4 or 5? I've lost count right now. But this is the video log that is to help my fellow county residents and citizens. That is the one and only purpose, is to help educate people just to our basic rights, you know, in the Bill of Rights. You know, you don't have to be some legal eagle to grasp your natural rights, your individual rights, your God-given rights. So with that, I'm going to take a quick break and get a drink of water, and I'm going to come back and do this last part with this First Circuit Court of Appeals. All right, I'm cutting off now.